Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us, coming to you from Washington's premier indoor shooting facility. Of course, that's Security Gun Club right here in Woodinville, Washington. Hey, America, we need to talk about pre-purchasing licensing, okay? Permit to purchases and stuff like that. We have seen a flurry of legislation flying around the country in these civilian disarmament states. We're going to talk about 3 of them today. And so it's got me doing a lot of geeking out on case law and also talking to various other lawyers. And the news may not be real good when it comes to this, but I want you to understand this is a big problem because gun control, as you know, is like rancid floodwater. It will seep into any crack or crevice it can get into, and once there, it will ruin everything that it touches. And this is a way by which you could be disarmed. We will explain it all to you in just a moment. So today, let's spend a few minutes and let's talk about how these laws could disarm you no matter what the Supreme Court says. Okay, America, so this is what we're talking about today. We're talking about permit to purchase laws. So we're going to talk about 3 of them in particular, but there has been a flurry of legislative activity nationwide. And I got to be honest with you, after doing a bunch of geeking out here, this is the new kind of in vogue way that they're going to use to disarm all of you. And this may turn out to be a very effective method. We'll explain here in a moment. Now, on a side note, I want you to think about just how offensive this law is on its face. Because what this law essentially says is you must first attend mandatory training, then prove your worthiness, then get a license from government before you can buy a gun. And if you just want to see how offensive it is, just take the words buy a gun out and put any other constitutional right, like vote, like go to church, like be free from unreasonable searches and seizures, and so on and so on. And you can understand just how offensive this law is and why it is that we often call the Second Amendment the redheaded stepchild of the Bill of Rights. Now, just to give you an example of what's going on around the country, let's first start talking about Colorado Senate Bill 3. Now, that was just signed by Governor Polis last week, and it has everybody in Colorado absolutely losing their minds, and for good reasons. However, to the folks in Colorado, I want you to understand that while many of you think that this is absolutely the complete Armageddon that you were worried about, it really more is a moment of welcome to the club. Okay, is it a bad piece of legislation? Yeah, it's a terrible piece of legislation. Is it the worst piece of gun control legislation I've ever read or seen passed? No, it's not that. No. If you want to find those, you go to California or you go to Illinois. But welcome to the club nonetheless. But I want you to pay very careful attention to what Colorado did there, because they started with an idea of we're going to ban the sale of all semi-automatic rifles, or what they wanted to label as assault weapons. But then it morphed into, well, okay, we'll still allow those to be sold and possessed so long as you obtain a permission slip from government. You saw this in Illinois to some degree with, we'll allow you to continue to keep the stuff you already own so long as you register it. But this is a permit to actually possess and or purchase that's going to occur in Colorado. And if you take a look at the details, because the devil is always in the details, there arguably is some very arbitrary methods by which local law enforcement can decide, we just don't think you deserve it. But I want you to consider a world where, let's say, Snope v. Brown has actually been accepted by the United States Supreme Court, and they have ruled, in fact, that assault weapon bans are in violation of the in common use doctrine, which they are, and therefore they are per se unconstitutional. Well, how are states like California, New York, New Jersey, Illinois, Washington, and all the other states going to continue to ban the sale of these firearms? They're going to do so through permit to purchasing, because they're going to require these permits to purchase these types of firearms, and then they're going to make obtaining those permits virtually impossible. The second piece of legislation is Washington House Bill 1163. Now, the state of Washington tried this legislation last year. It got watered down significantly into a mandatory education class, but now it is turning into a full-blown license. This is sitting before the state Senate. It's going to be voted out of the Senate. It will have to go back over to the House for a quick reconciliation, but this thing is fast-tracking itself to the governor's desk and will be signed into law. This piece of legislation includes mandatory live fire training. And here's the thing, if you take a look at Washington's law as to what it constitutes to transfer a firearm to another person, there's a real question as to whether or not a first-time gun buyer, that is someone who's trying to dip their toes into the Second Amendment waters for the first time, could even take the live fire training, because they would not have a firearm to use during that training session, nor would state law in many instances allow someone to loan them a firearm for that purpose. And remember, Washington, even though you might be able to temporarily transfer firearms to family members, you won't be able to do so unless they have that permit already, which means you won't be able to actually loan or borrow a firearm from a family member to take the mandatory training. So not only does this create literally an impenetrable barrier for first-time gun buyers to try to get into the Second Amendment community, it also adds to Washington's already long 10 business day waiting period an additional 30, perhaps 60, even 90 days before a person could actually obtain their first firearm. Now, who does that affect the most? Well, candidly, it affects battered women the most. Yeah, it does, because unfortunately, the no contact orders and protection orders and things like that they get seemingly don't work. They're much like gun-free zone signs. Shockingly, criminals just don't read them. And so when many of these women find themselves in horribly dangerous situations and they have to take matters into their own hand, Washington state law will now actually extend the time in which their lives will be endangered without their ability to do anything about it. This law will not save lives. This law is going to cost lives. And then finally, let's talk about California Assembly Bill 1187. Now, as you can imagine, California already has a permit to purchase regime because, hey, they're California, the genesis of all crazy gun laws. California now is also faced with the sad reality that they might actually have to issue out-of-state carry permits. They clearly don't want to do that, but they might have to. So what are they going to do? Well, they're going to pass Assembly Bill 1187 that says now, if you are going to bring a firearm into the state of California, so you are transporting a firearm into the state of California, you are an importer bringing firearms into the state of California, you will have to complete California's approved safety class before those actions may occur. So, you will see many other states begin to pass these mandatory licensing regimes, and then, even for out-of-state carriers, until they have completed that in-state regime, they will not have the ability to carry a firearm or even transport or possess a firearm inside that state. But you see, America, here's my biggest concern, because I know many of you are just kind of rolling your eyes and saying, well, this is blatantly unconstitutional. But is it? That's the thing. And this brings us back to Bruen Footnote 9. We did this video about it right here. Now, Bruen Footnote 9, which was meant to be a shield from frivolous litigation against shall-issue regimes, has unfortunately been turned into a sword that is used to justify every sort of crazy civilian disarmament piece of law. But you see, as long as the criteria for these permit to purchase remain objective, obtainable criteria, well, the concern is that the United States Supreme Court would never review even such a licensing regime. Because Bruen Footnote 9 clearly states, to be clear, nothing in our analysis should be interpreted to suggest the unconstitutionality of the 43 states shall issue licensing regimes under which a general desire for self-defense is sufficient to obtain a permit. And if you take a look at most of these laws, with the exception of perhaps one clause in Colorado, yeah, these are objective criteria by which anybody could obtain. It may take a lot of time, it may cost thousands of dollars, but they are obtainable criteria. Bruen Footnote 9 even further stated, because these licensing regimes do not require applicants to show an atypical need for armed self-defense, they do not necessarily prevent law-abiding responsible citizens from exercising their Second Amendment right to public carry. So again, this is not using any of the subjective criteria as the laws are passed right now. But the only saving grace to be found in Bruen Footnote 9 is the last sentence, which reads, that said, because any permitting scheme can be put toward abusive ends, we do not rule out constitutional challenges to shall-issue regimes where, for example, lengthy wait times in processing license applications or exorbitant fees deny ordinary citizens their right to public carry. So America, here's what they're going to end up doing here. You're going to see a lot of states pass these laws, and they're going to say, no, this is really very objective criteria. They just have to do some mandatory training, go through a background check, pay the fees, they're good to go. And that will be the way the laws are passed. And then year by year by year, these state legislatures will slowly ratchet up the requirements, and they will add more subjectivity to the criteria. And of course, every time they do that, there will be an increase in cost. And one day you will wake up and realize that obtaining a permit to purchase a firearm is a nearly impossible task. And that is the way that they will use permit to purchase to disarm many of you. Okay, listen, if you have any other questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. But if you don't, that's okay. That information, it's down there in the description box. If you got an idea for a video we should be doing around here, you click on that link right there and you tell us all about it. If you want to subscribe to the monthly newsletter, the ability to do all of that's down there in the description box. And then finally, and most importantly, America, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching, and stay safe.